Hey everyone, and welcome to On Trial, the podcast where we explore how to build your practice, trial tactics, and what can make and break your case. We're your hosts. I'm Matt Heimlich.
And I'm John Risvold.
And today we have a kind of an interesting topic because recently it's become applicable to any case you're going to handle. Defense medical experts, anything from an auto case to a construction case to a med mal case. The defense is going to hire an expert to dispute the causation and to try to minimize your damages, no matter how big or small your case may be. John, I know you've been experiencing a lot of that recently on some of your auto cases in particular. Why don't you give us an overview of kind of who these experts are and what they're trying to do?
None of your clients are injured any longer, according to the defense bar. None of them. No matter how large or small the injury, no matter what the circumstances, it was not wrongfully caused and they're perfectly fine. They're all malingering, or they all overtreated, or the bills are all inflated, or biomechanically speaking, the force of the impact was impossibly, it was not enough to cause this type of injury. I mean, I'm seeing everything in every kind of case. We just had a case. It was a smaller case in our office, and it was like $38,000 in medical. And one of the big insurance companies hired a well-known expert to contest the bills, a billing expert. And even she came back and said, well, 36 of it is related to the crash and totally fine. And so they knock off $2,000. And then they hired a PM&R doc to say, oh, well, your client overtreated. Well, the client's listening to the physician, the client's listening to whoever their treaters are and doing what they're supposed to do. And so they're bordering on nonsensical at this point. There are instances where some of these experts are legit, and there are cases where they are, battle of the experts cases. But a lot of these, mid-size auto cases where you're seeing, the run-of-the-mill neurologist who has the same report that looks like the last report, then looks like the report before it, and you pull 6 or 7 cases that she's been on, and all her reports are cut and paste. I'm seeing a lot of those. And I don't know if it's just the defense bar trying to muddy the waters, or if it's a temporary strategy, but it's become, as we are emerging or getting onto the back end of the pandemic, this has become like the hot new thing. I don't know if they have like a DRI about it where, they think that they can hire experts and contest liability and contest causation effectively. But with no trials, it remains to be seen whether it'll be effective, but I'm seeing them all the time.
Right. And some of the things that you need to consider, once you get someone designated as an expert, first of all, do they have a report? And if they do, read it in conjunction with their disclosure, and then figure out, do I actually need to take this expert's deposition? More and more, I'm seeing the utility in not taking experts' depositions, locking them into the opinions set forth in their disclosures or report. A lot of times I find them to be general. I find them to be vague. I find them to lack in foundation. And I find them a lot of times, especially in auto cases, for them to these experts be testifying things that are outside the scope of their expertise. So you need to figure out, obviously it's a case by case basis, but you need to figure out, do I need to take this deposition? Will it ultimately benefit me to do so? Because a lot of these, especially in the auto cases, these are people that testify all the time. They're pretty good at getting into their opinions when they're asked, or even if they're not asked, they'll start talking about what their opinions are on a given matter. And then all of a sudden you're opening the door and allowing them to expound upon, add new opinions that they otherwise wouldn't be able to offer if you hadn't given them the opportunity at the deposition. So for me, that's kind of the first threshold question that I ask myself once an expert is designated is, do I actually need to take this deposition? Will this help or hurt the case?
I'm with you 100%. More and more, I'm choosing not to depose defense experts. And it's not because of any sort of laziness or because I don't think I have the ability to go toe to toe with any of these experts. It's because exactly what you're describing. We have very, very strict expert disclosure rules in Illinois, and other jurisdictions have similar, but ours I think are really fantastic. And it's as simple as, you as the lawyer have to disclose all the opinions of your expert and all the bases of those opinions. And if you don't do that and you don't do it well, your expert is hamstrung. You can get experts stricken because their disclosures are not, flushed out enough. They're not specific enough. In fact, there's a lot of really good case law in Illinois that says with Rule 213, which is the Supreme Court rule about expert disclosures, 213F3, is that you have to, and I'm quoting from the Supreme Court of Illinois, you have to drop down to specifics. You can't just say the expert will talk about causation and how the crash didn't cause the traumatic brain injury. That's not enough. You have to say how, what's the basis? How did they come to this conclusion? What did they review? What are they looking at that the treating physicians aren't looking at or aren't relying on? What's the difference? And a lot of times you'll see very bare bones disclosures with no report. And when I see that, I think that's fantastic, because if you take the deposition becomes part of the disclosure. And so if you're not taking the deposition and they have a crappy disclosure and it's, bare bones and it's horrible, sit tight and wait till trial. And then your motions in limine should be chock full of motions to bar these experts who have not, properly disclosed or adequately disclosed their opinions. And oftentimes you can get some of these opinions stricken because you have no idea what they're going to say when they get on the stand, because the defense lawyer didn't do their job.
No, you're absolutely right. So what if you decide to take the experts' depositions? The next thing you're probably going to look at is their CV. What are their degrees? What are their qualifications? What have they published, if anything, that may be relevant? What societies or organizations do they belong to? All that can provide some really good fodder for your examination, particularly with societies and organizations, because a lot of medical societies have publications and guidelines that you can pull, that most of them are publicly available, as well as ethics and bylaws, particularly about testifying. I know the American Medical Association has ethics and bylaws pertaining to physician medical legal testimony. The AMA and other organizations have publications and guidelines that you can definitely refer to and use during cross-examination. And if that expert is a member of that particular society or organization, they're going to have a hard time saying, well, that doesn't apply to me. That doesn't apply to this case. In addition, you figure out what their expertise is. Are they like you said, a neurologist, and are they testifying about orthopedic issues? Are they an orthopedist, and are they testifying about neurological issues? A lot of times the defense wants to to cover the waterfront with one expert. You see that a lot. And a lot of times those experts ended up reaching on their opinions, talking about things that they really don't have the foundation to be talking about, particularly, when they're going up against a treating physician who is certified in that particular specialty. And, again, that's another decision to make. Do you want to leave that opinion and just, crush them with your treaters, or do you want to try to get it out? But, make sure you identify those particular issues and figure out, how you want to approach it. Do you want to attack it, during the deposition, or try to undercut it and get it barred? Or do you want to leave it be and, leave that as something for your cross at trial?
I think people underestimate the value of the CV and the amount of information that's there. And so take, for instance, if you're listening to this podcast on your phone, you're holding in your hand every piece of knowledge in human history, easily accessible in a second. Look up whether or not this doctor actually works where they say they work. Go to the website, see if there are headshots there. You'd be surprised how often it's not there. It doesn't show up. And you get into a deposition and say, you work at XYZ hospital. Well, not anymore. Okay. So you don't see patients anymore at all. No, you only do this work, right? You just get files from State Farm or Allstate, and then you copy and paste the same opinion over and over and over, and then come into court and tell us all that our clients are faking it or lying or malingering or whatever it is. You can find those things pretty easily. And the other thing you have to do is go check their license. Their license numbers are going to be on their CV. Go look up and see if their license is current, see if they've ever been disciplined. I mean, I did that in a case recently where the defense was using a treater as an expert. And my entire cross of him was, you were disciplined for falsifying records a year before you saw my client, right? Right. And so we have no idea whether or not these records are accurate, do we? And then he hemmed and hawed and stuttered, and that was the end of my cross. And they will never call that guy at trial. You'll never see him again. You'll never hear from him. And all I did was Google his name and look up his license. It's that simple. There's so much good stuff in the CV that you have to start with there. I see so many transcripts, because I'm the nerd that reads transcripts, right? I see so many transcripts that just say, like, is this your CV? Is it current? Okay. And then just moves on into whatever the director, the cross is of this expert. And I think you're missing opportunities.
Right. A lot of that's work done before you sit down to take the expert's deposition. There's a lot of homework to be done. And that's, you put in the work, you put in the effort, and you really can unearth some really good things that are going to help you and your client. Another thing that you certainly should be doing prior to taking your expert's deposition is trying to figure out what other transcripts are out there. Is this a frequent flyer expert? Talk to the people at your bar association, talk to your friends, talk to your colleagues, see what else is out there. A lot of these experts, someone likes them and then they get used all the time, particularly on the defense side with some of the larger insurance companies. So odds are, if someone's been designated, there's going to be a lot of transcripts out there. So figure out, do they have common practices? Do they come to the same conclusion on every case, no matter what the facts are? Is it, a cut and paste kind of report that they're offering? Compare it to others, things that you can find out there. And I think if you can expose that, if you can expose those kinds of practices, to a jury, if you can put, and I saw this done once very effectively, a table was laid out and stacks of transcripts as high as you could possibly imagine, and stacks of reports as high, just feet off the table, just saying like, you came to the same conclusion in this case, in that case, in the other case, and your report looks exactly the same. And you call out the game, that this expert's playing. I mean, that really resonates. That's going to score you big points, and it's going to lead, to them, to discrediting your expert. You do that in front of a jury, it's going to do a world of good for you.
Yeah, I feel like a broken record when I say this, but I think the most important thing in front of a jury is credibility of the witnesses, the court, and the attorneys. So if you're acting unprofessionally, you're going to lose credibility. If you're lying, you're going to lose credibility. If you can show that the credibility of the expert witness is shaky, the jury's automatically going to be distrustful of them. They're already distrustful of lawyers. They're already distrustful of the process. And so you can use that to your advantage with some of these experts and show that these experts are not credible, that they are just hired, guns to come in and say whatever they need to say to get their paycheck. And I think that can be really, really effective in front of a jury. The minute they lose credibility, it's over for them.
Right. And that kind of segues into the next area that you really need to explore. And a lot of this information can be requested directly from the expert within your deposition rider. You got to have a nice, thorough, comprehensive deposition rider trying to get as much information to them as possible. And two of the areas you really need to probe are their finances. How much are they making from their medical legal work? Is it a couple $1,000s a year? Is it $10,000? Is it $100? Is it $500? Because all that's going to make a difference. And then do they split evenly as far as advocating for plaintiffs versus defendants? Are they all defense all the time? Are they, 50-50? Again, that goes to credibility as well. And that's something that you're going to want to know and need to know. Again, that goes to the weight, the credibility, and how a jury is potentially going to perceive that expert.
A lot of these experts don't want to give up that information. They don't want to tell you how much they make or how much of their income as a percentage even is from medical legal testimony. They want to be able to sort of hide in the weeds and say that they're treating physicians and they're just trying to do the right thing because they think all of us plaintiffs' lawyers are greedy. The one thing I will say about deposition testimony is that if you're not getting this information from your rider, if you send out the subpoena to the expert and it comes back and you're not getting the income information and you can't find it in other transcripts, that is a really good reason to take a very truncated deposition to find out these sort of bias issues. But, you want to be careful that you're not exposing yourself to the expert, allowing themselves to expound upon opinions. But that's very, very important information. If you find out that this expert is just a person who only does medical legal work, and they don't do any real hands-on patient care, that I think is going to resonate with a jury because your treaters are going to testify to causation. Your treaters actually laid hands on your client as a patient and have actually examined them and seen them. And this doctor hasn't seen anything except a summary of the medical records that someone in their office did or someone at the insurance company gave them. They're not reading thousands of pages of medical records. They're not reading hardly anything. They're getting summaries of all this stuff given to them so they can formulate their opinions. So you need to find out, how much they're making, how much of it is, part of that bias, one side or the other.
Before we jump into that next part that you brought up there, I did want to kind of hit on one more point. You also want to explore, in addition to their testifying history in general, their prior and current work for the firm they're being retained by. I think that's a very ripe area, and because, once you get to know someone, and this is true for anybody. I mean, I was guilty of this as anybody else. You find an expert that you like, you want their opinion on a given case. And I know that there was an expert that I had used in the past, for both plaintiffs and defense cases. And the best criticism of him that I heard from anybody, because no one could get him really on the merits of what he was saying, was that, when this firm needs an opinion, they go to the well and they call Dr. So-and-so. And Dr. So-and-so's, whether it's for the plaintiff, whether it's for the defense, Dr. So-and-so's there. And he's going to advocate for them. And while they couldn't get him on the medicine, while they couldn't get him on the merits of what he was saying, I thought, when I sat back down after the examination was over, I thought that is by far the most effective critique of what my expert was offering. And it's something that, people should be aware of, and people should definitely explore when an expert gets designated.
Yeah, I really like that. I think it's a really smart way to attack the credibility of an expert, to say, well, they might as well just be working in your office at this point, right? Do you have an office set aside for them so that they can do all this work for you? This is the 11th case that they've testified for you. That works really well with some of these big carriers too, because, you'll see the same names that are the captive counsel for State Farm, Allstate, whoever. And I know I pick on those guys a lot, but they deserve it. You'll see the captive counsel, those names. So, like these 5 firms are all Allstate firms, right? So you can just check all of them off and say, well, this is the insurance company that paid for, your last vacation, right? This is the insurance company that pays your mortgage. And you're in here trying to tell us that my client's lying. You can tell as I'm talking about this that I find a lot of what these defense experts say, especially in auto cases, to be incredulous and ridiculous and almost an affront to the whole system. But there are really easy ways to expose that, and really easy ways to sort of turn it on its head and get some easy points. One of them is exactly the way that you describe it. Another one is, what did you actually review? You didn't read this transcript, did you? You didn't see these medical records, did you? I had an expert on the stand the last trial I tried, and he said it's important to have all the facts. And that was one of the last things he said in direct. And in cross, I got up and I showed him a blow up of one of our exhibits. I said, you've never seen this, have you? No. This is an email that says that there's a dangerous condition on the property that needs to be fixed. And it was sent a month before my client fell on that same dangerous condition. That would change your opinion, wouldn't it? Actually, yes, it would. And then we were off to the races. Right? Because he hadn't seen the smoking gun in the case. He hadn't seen a key piece of information, and he had formulated his entire opinion sort of with blinders on. And so even on the stand, he was either forced to lie, to the jury, which they can see, or to fold. And I think you can create those opportunities just by finding out in your rider, what did you actually look at and review? What are the actual bases of your opinion?
No, that's an incredibly important thing. What they haven't seen is obviously much more important than what they have, because if they haven't seen something like you just talked about, that could be the difference in their opinion, and it could change everything. In addition to what they've seen, there's often the issue of, if your client is, alive at that point, did they examine your client? If they didn't, you gotta find out why not. It's not important to examine your client. I have 3 treating physicians testifying who saw my client collectively 65 times, and if they did examine your client, talk with your client, find out how the exam went, and make sure you point out, during your examination of the expert, that this expert has no responsibility for the well-being of your client. There's no real physician-patient relationship between the expert and your client. And another tip, which I think is a great thing to do if your client is going to sit for a physical exam with a defense expert, send him to his treating physician before and after.
That's a great point.
Compare and contrast that with what the expert says. A week before, have him go to the doctor for a checkup, have him do a thorough exam, see how he's doing, have him make a note. And then the week after, have him go back to the doctor and have that note too. And then see where the differences lie. I think you'll be amazed at how different those things can be, the conclusions that are come to, the diagnoses that are made. And you can really use that to, again, explicitly show where the bias lies and how that can affect, how a medical doctor, even one in the same specialty, will view your client and your client's injuries.
I really like that idea. Another thing that I've seen employed effectively, and you'll usually need a court order for it, is you want to be able to videotape the exam that the defense expert does of your client. And if you can't videotape it, try to have some sort of, medical expert there of your own, whether it be your own expert, or you have an in-house nurse, or you hire a nurse, or you hire somebody with some sort of expertise or background to understand whether or not the examination that's being conducted is actually a legitimate examination, or whether they're sort of fudging the facts. I think it's really, really important. You'll need the court's intervention 9 times out of 10. I can't imagine a defense lawyer is just going to say, yeah, sure, no problem, come on in. But if you get that court order, that can shut down the entire exam pretty quickly, or delegitimize the exam that's already illegitimate.
It's extremely important. You got to make sure that everything is above board and everything is disclosed. That's really the nature of this whole thing. Is it's supposed to be an open and fair process. And, you got to make sure that that's what actually occurs. So, let's say you sent out your dep rider, you have their complete file, you've got the billing records, you've got the financial information, you've got the correspondence relating to the case, you have whatever they're relying on, whether it be records, journals, articles, you got their testifying history. Now, it's time to prepare for the deposition. You're getting your outline going. Most important thing in my mind, when you're preparing your outline for the deposition, is what is the goal? What is the goal of this deposition? Are you trying to lock in or limit opinions? Are you trying to undercut opinions? Or are you trying to outright disqualify this expert? Because that's going to kind of change how you approach, the various aspects of it. So figure out what exactly it is you want to do, and then tailor that outline accordingly. If you want to lock in and limit opinions, you just want to close them off about what they can and what they can't testify about. If you want to undercut opinions, you're going to be attacking the bases. You're going to be, just like John said, you're going to be like, well, you didn't see this information. Had you seen this, had you saw this information, you would have done something different. Your opinions would change, right? Or if you want to flat out disqualify the expert, you're going to say, this is outside your scope. You are not qualified to render this opinion, after going through the requisite foundation. So there's a couple different goals that you want to achieve when you decide to take that dep, and make sure that your examination is targeted and focused on those goals.
I agree 100%. I think if I had to rank them in order, I want to go to disqualify first. If I can knock out this expert somehow, some way, I want to do it, and I want to do it quickly in a deposition. If I can't, I want to, lock them up and limit their opinions. I personally very rarely go to number 3, sort of the discredit and attack the opinions. That's all trial stuff for me. I don't want them to see my hand. I want to hold that close to the vest. But to your point, if you can disqualify them simply by laying the foundation and saying, well, you're an orthopedic surgeon, you don't, do neuropsych evaluations, so you have no idea whether or not this person actually sustained a traumatic brain injury, for instance. You don't do that. You're a spine surgeon, right? You're not a neurologist. You're not a neuropsychologist. You're not a PM&R doctor. You're not somebody who would have that sort of expertise or background. You're not a neuroradiologist, are you? No? Okay. And that alone might be enough. You don't always have to get sort of a knockout punch in the deposition. The knockout punch can come with your argument in the motion limine by saying, look, this is the opinion they rendered. They're wholly unqualified. They've never published an article about this. They've never really offered this opinion before in court, or they've never been qualified as an expert to offer this opinion, and it's outside the scope. And if you can just show those things and set them up in the deposition without really showing the expert or the defense lawyer what you're doing, by being calculated and being very meticulous about your planning and being very well thought out and planned out in advance, and having practiced and having, dry ran all of these questions and sort of your crosses, you can disqualify at least portions of expert opinions more often than you would think.
Yeah. So the first thing I'm looking to do once the deposition begins is, show them their report, show them their disclosure, and just confirm that all of their opinions are contained within this document, that there aren't other opinions we didn't talk about. Again, you're kind of opening the door at that point, but you need to kind of explore that area. Once you're taking the dep, you got to rein them in, narrow the scope as much as you can, confirm that all opinions are in the disclosure, and confirm that the conclusions that they made are not facts, they're opinions. I know that seems, simple, but again, this is for the jury. It's not for you. It's not for opposing counsel, but you want to confirm that the conclusions are not facts, they're opinions. The films, the records, the depositions, those are the facts. And these are this expert's particular opinions based on the facts. And, another expert could come to a different conclusion based on those same facts. So you got to just, make sure that you differentiate fact from opinion. Then you got to ask what their role is. You've been retained by the expert. Are you a professional witness? Are you on the defense team? And then contrast that with their ethical obligations pursuant to, the medical groups that they're probably a part of, pursuant to the American Medical Association or the, whatever specialty they happen to be. And just, kind of point that out and make that clear to the jury that, they may be straying from what they're supposed to be doing, as an ethical doctor by testifying the way that they are in this particular case. And just put that out there, and then go through what they did to prepare. Sometimes you'll be surprised that the answer is, I just looked at my report and then I showed up.
Yeah, that's the answer a lot of times is I read over my report again. And then I talked to my lawyer and then I showed up. That's it. You're right about the first part. And I think it's really important. I think we can lose sight of that very quickly. These are just opinions. They're not hard facts. They are not, the facts of the case. They are these experts' opinions. And, I've said this repeatedly. You've said this repeatedly. Like, don't open the door to allow them to expound upon their opinions and to, create new opinions. But you have to crack the door a little bit, and you have to sort of poke and test and prod and see the outer limits of what their opinions are. And you can do that carefully. It is an art, not a science. It takes practice. It's not something you're going to be able to do your first time very well, probably. I know I didn't the first time I took an expert deposition. I'm sure it didn't go as well as the last time I took an expert deposition. But you're right. You have to test those boundaries and see. But I really, really like the idea of using their own organizations and their own societies and the things that they've agreed to publicly with their peers to a certain set of facts or rules, using those against them at trial or even in a deposition, because a lot of times the way that they're required to formulate their opinions or the way that they have formulated their opinions is in direct violation of these things. And so they have to make a choice there in front of a jury. Are they going to be strictly ethical, or are they going to take the pay and take the money and run? And, you can create that dichotomy, and then you get up in closing argument and say, you heard Dr. Smith, and Dr. Smith was paid 10 grand to come in here and lie to you. And I mean, obviously don't say something like that. It's objectionable and you're going to get your verdict thrown out. But you make that claim and make that case by pointing out, look, they violated their own rules. They violated their own standards. And it's just like any other rules of the road kind of thing, right? If you're in a nursing home case or a trucking case or some sort of regulated industry, you have your rules. Experts are the same way. Like, they have their outside rules. They have, we have our own rules that they're bound by, and you can use the rules to your benefit, provided you know them and you know how to use them and you know the case law and you know exactly what their background is. There's just a lot of work that needs to be done before you ever set foot in that deposition. But if you do all that work, the harder you work, the luckier you're going to get in the deposition and at trial.
To paraphrase the great Keith Mitnick, are you a paid persuader or are you an educator? Let the chips fall where they may, and you got to find that out. And that's really what it's all about. And that's what's going to matter to the jury.
Absolutely.
And then, once, and this is something I'm particularly a fan of because I love talking about this in opening, what are your areas of agreement with the defense expert, despite everything that we just talked about? And it may be as simple as, was the client injured because of the fall, because of the wreck? You may disagree about what the injury is, and that's certainly, common, but was the client in fact injured because of the wreck, because of the fall? And believe it or not, I mean, that can send you on totally different paths with your deposition, because if the expert says no, I mean, that's a whole different thing. Then you can go into malingering. You can go into, you're not an expert on malingering. You're not an expert on this. You're not a psychologist. That's a whole different line of questioning. And if you get to yes, then, you get to get up an opening and say, listen, everyone agrees that this wreck caused an injury. We're all here today because my client was hurt because of this wreck. The only disagreement that we have is the injury that was sustained. This expert is going to claim it's a sprain strain, should resolve within weeks to months. And my treating physicians, the people who actually see her day in and day out are going to say it's something very different from that. but you got to start with that basic, simple premise. And once you get there, it can really takes that, because obviously everyone's skeptical of you and your client showing up and asking for money. They think, that they've bought into a lot of juries, they bought into those things where, there's a lot of frivolous lawsuits out there. And once you say everyone agrees that there's an injury caused by this crash, that goes out the window. And now your credibility is established. And now your client's credibility is established. And then it just becomes an argument over, okay, what are the injuries? How much it needs to be awarded ultimately at the end. But you got to start there. And I think that's absolutely critical and something you definitely need to highlight very early on in the deposition.
100%. The best thing I think you can say in opening, and you said it a couple of times in what you were just saying, everyone agrees. Now the jury agrees because everyone agrees. Everyone agrees X. Everyone agrees Y. Well, now the jury doesn't have to think about it anymore. Oh, everybody agrees. I agree with that. Okay, that makes sense. And you're right. The system outside of the courtroom has conditioned the billions of dollars that are spent to do this, have conditioned everyday people to believe that most lawsuits are frivolous, that they aren't justified, and that people are just trying to look for a payday or, their lottery win or whatever else. And so when you can get up and say, well, everybody agrees my client is injured. Okay, well, now we're just talking about how injured are they? Everyone agrees the defendant is at fault for this crash. He admitted it in his deposition. He's going to admit it on the stand that he, caused this T-bone collision, right? And now you don't really have to talk about liability. You don't really have to really hammer liability as much. It becomes a damages case. And so that phrase is something that you need to seek out and find when you're working with experts. Find those points, lock them up, hammer them home, and use them from the get-go. Absolutely.
Yeah, absolutely. The next thing that I really like to do, again, to have that really nice, make that nice argument in opening, is contrast the expert with your treaters or your experts if you had to hire them. What are the specialties? You read Dr. So-and-so's dep. He's a board certified orthopedic surgeon, isn't he? Oh yeah, he sure is. You also read, Dr. So-and-so, who is a pain management doctor, right? Okay, yes. And that's not your specialty. That's outside of the scope, right? And you kind of just have them qualify your treaters and have them testify that these are people who are licensed in different specialties that are related to the injuries that your client suffered, and that their opinions are based on how much, and talk about how many times they saw the patient. My orthopedic surgeon, Dr. So-and-so, the orthopedic surgeon, saw the patient, 17 times or however many it did. And the PM&R and the pain management doctor saw, him once a month for the 2.5 years after the accident, right? Have them qualify your experts and speak, or your treaters, and have them speak to the amount of contact they had with your client that this expert undoubtedly did not, because usually they examine them 1 time or 0 times in all likelihood. Right. So you definitely want to talk about that. Talk about how they weren't hired to help the patient. That's you, the treaters, you go see a treating physician because it was recommended to you and you need medical treatment. They're there to help. This expert obviously is not. That's not their job. Their job is, in fact, to, I wouldn't say do the opposite, but it's to limit, and kind of call into question, what is actually related to whatever injury you're claiming. And so that's a very important thing to kind of, talk about their purpose in the case versus your treater's purpose in the case.
Yeah, absolutely. Like the idea of having them qualify your treaters. And one of the ways that I've found to do that I like a lot and that works really well is to simply say, you read the deposition of Dr. Jones, and that Dr. Jones is a board certified orthopedic surgeon. You read that deposition, right? Right. And you found, you relied on that deposition in forming your opinions, and that deposition was reliable in forming your opinions. Now, you can get up and say, because they're going to say yes to that. They relied on it and it's reliable. Now you can get up and say, even their expert agrees that our treating physician's testimony is reliable because they relied on it in forming their own opinions. Their opinions are paid to be something different, but Even they agree that the doctors you're going to hear from are reliable. And then the jury automatically thinks, again, everyone agrees, so I must agree. And I think that's a really easy way to add credibility to your treaters. I think that's a really good idea.
Yeah, and then the next place I like to take it, presuming that the expert has a clinical practice and they're seeing patients on a regular basis, which they aren't always, as you talked about before, but presuming that they are, and presuming that they are questioning the veracity of the complaints that your client is making. They're saying either they're exaggerating, they're malingering, they're over treating, whatever it may be. Or pain is subjective, which is always a fun thing we'll get into a little bit later. You can ask them, do you question the veracity or source of the complaints you receive from your patients? And if so, under what circumstances? Put the ball in their court, because they're making this claim about your client, usually based on, again, one examination or zero, based on a review of medical records, and based on very little else. And so, but they're calling your client's credibility into question. So in what circumstances, as an actual treating physician, assuming that they are a treating physician under some circumstances, do they do that? And, the answers may surprise you. It could be anything. So just make sure you find that out and, put their credibility on trial, because they're putting your client's credibility on trial. So put theirs, out there and see what you can do with that.
Absolutely.
And then there's, the medical aspect of these cases. And again, this is something I generally don't like to dwell on unless I absolutely have to, because it validates their status as an expert. You don't necessarily want to do that, particularly, again, if they're talking outside the scope of what they should be talking about rightfully. You don't want to give them the credibility to say, oh, this didn't cause neurological issues, and here's why. They shouldn't be talking about that in the first place if they're not qualified to do so. And, that's something I try to avoid at all costs. I mean, sometimes, standard of care experts, medical malpractice case, obviously you got to get into it. But other than that, I try to not argue the medicine. Argue the medicine with a doctor is generally a losing concept. Yeah. I've seen it play out at trial a few times, and all it does is give the expert credibility, even if it's deserved credibility. I mean, one of the last cases I tried, the defense attorney got up and he went way beyond the scope of direct, and I let him do it because he was arguing the medicine with my doctor. My doctor was just kicking him over and over again. And I was like, this is great. I'll let him do this all day. And we asked the jury about it afterwards. They're like, I didn't understand any of that, but it was very impressive. That's what they said.
Yeah, right.
They said that was I was very impressed with the way your doctor handled everything. I didn't understand a word. It made no difference to me whatsoever, but it showed that your doctor knew exactly what he was talking about in my mind, even though I didn't understand anything that was actually being said. So don't do that. That's my advice. Don't do that.
Agree. That's one of the best pieces of advice I got as a young lawyer when it came to experts was learn the medicine and then never argue the medicine with the expert, especially when we're talking about depositions and trial, of course. But I agree with you 100%. It's a losing battle. Now lock them into what their opinions are based on their review of the review of the medical and everything else. Lock them into those medical causation opinions, which is why you have to know the medicine and have to be able to understand it and speak about it, but don't argue with them about it. The MRI didn't show XYZ, did it? Well, as a matter of fact, if you look at this film here, and now you're dead. Now it's over, right? You can kill your own case by arguing the medicine. So I'm 100% with you. I think that is just rope that you use to hang yourself.
The next thing that you really want to do with these defense medical experts is really just gut the general legal defenses that opposing counsel is going to make to your case. Obviously one of the biggest ones is, the person's prior medical issues, or that, they had a degenerative condition that was going to inevitably lead to them being in pain, or them having disability or debility or whatever they want to do. And really, you can counter this through, in most cases, just through basic common sense. They weren't in pain to this particular area of the body the day before the crash, or even if they were, they had some chronic spine pain. They were seeing the chiro once a month. They weren't seeing an orthopedic surgeon. They weren't going to a pain management doctor. They weren't getting shots. None of this treatment that your client has gone through after the accident was ever contemplated before the accident. Have them confirm that trauma can exacerbate these pre-existing conditions. You can have a degeneration in your spine, but it wasn't symptomatic until the car wreck.
Right.
Have them confirm that, and also have them confirm that, we can disagree on what the diagnosis is, but the wreck caused the pain and the pain led to the treatment. Yes. And once they confirm that, all of a sudden you have a causal link between the wreck and the treatment, whether they agree the treatment's related or not. They've already established that. Because again, point out the absurdity of the alternative. The alternative is the crash is just a big coincidence.
Right.
They were going to the chiro once a month. They have this car wreck. And then, all of a sudden, just magically, just coincidentally, now they need a pain management doctor. Now they're getting shots. Now they're getting injections. And the crash is just a happenstance. It doesn't really, there's no causal relationship there.
Super weird.
Exploit and expose the absurdity of the positions just by common sense and just basic stuff without, again, not getting into the hairy little details of the medicine can be a really effective tool in exposing these experts, for what they're trying to do in this trial, which is discredit your client without a adequate basis.
I think this is especially true in spine cases. I think that you can do this very, very effectively in spine cases. It starts with knowing what the jury instructions in the great state of Illinois say. And part of that is we're an eggshell plaintiff state, which means that if there's an exacerbation of a pre-existing condition, that you cannot reduce the plaintiff's recovery because their pre-existing condition was exacerbated. But the jury instruction also has some really sweet language that everyone forgets that says if they have a condition that leaves them more susceptible to injury, and you will get a lot of doctors to agree with you that conditions like a listhesis leave somebody more susceptible to future injury or future pain with trauma. And you will get them to agree to this over and over and over. And then you get a spondylolisthesis case and the defense is, well, that's a pre-existing condition. Yes, it is. That's 100%. You're right. I had no argument, but it was not a painful condition. And following trauma, it became painful. And your doctor, my doctor, all the doctors say that following a trauma, that condition can become painful. Well, weird. That's what happened here. What a coincidence. Those sorts of things, the susceptibility part of it, I think gives you a lot of leverage and a lot of opportunity to also take the defense expert's opinion and mold it into something very useful for you, because the medicine is what the medicine is. You have to learn it. You need to learn it, and you can use it without getting into the fine detail, right? You're not arguing the medicine anymore. You're stating a fact, an objective fact. You're not saying my client's particular case was this and became that. Instead, what you're saying is this particular known condition is a pre-existing condition. We'll all agree, right? But it can be not painful. And then it can become painful if they're in a trauma of some sort, right? And a car crash is a trauma on your spine, isn't it? Our bodies aren't designed for that, are they? No, of course not. And there you go, right? And then you get your pre-existing instruction, and you just have to educate the jurors as to what the law is in closing argument.
Yeah, we are lucky to practice in the state with some good jury instructions on those particular issues that are so common, particularly in car wreck cases. Another defense that you hear often is that your client underwent unnecessary treatment. That these symptoms resolved, or whatever they're saying. They're saying the treatment was unnecessary. It went above and beyond what the actual needs were. And your client is basically saying your client is inflating or attempting to inflate the value of their case through this treatment. And again, a good way to expose the, what I'll call flaw in that argument is to, take it to its most extreme. Are you saying that the doctors, therapists, chiropractors that perform this treatment were committing malpractice and billing fraud? See what their answer is to that question. The answer is going to be like, well, no, I can't say that. I can't. If that was truly your opinion, wouldn't you be required to report it as an ethical doctor? And the answer is that they're never going to answer that question. They're never going to give you a straightforward answer, because the answer is, well, that's just their opinion. They're not treating the patient. They're paid to have that opinion. And again, it'll expose that to the jury, and the jury will come to, more often than not, the correct conclusion, once they hear what they should be doing if they really truly in their heart believe that that was what was going on.
Yeah, the flip side of that coin too is you're telling this jury that my client should have just ignored their doctors. The doctors prescribed this treatment, didn't they? Like, this doctor referred my client to PT, and the physical therapist did an evaluation, came up with a plan, and that plan was 12 weeks long instead of 8 weeks long. And you're saying that my client should have just quit early? She should have just ignored it and walked away? That's your testimony, right? She overtreated. She treated too much. She tried to be too healthy and tried to get too much better. Those sorts of arguments, I think, are just absolutely absurd, and you can expose the absurdity very quickly. So do make sure you expose the absurdity of it.
Sure. Another thing that you hear a lot from experts is they try to dismiss anything that can be perceived as subjective. They always want objective findings on diagnostics, and they do this particularly with pain. They talk about how pain is a subjective complaint. Everyone experiences it differently, and therefore it's not something that we can really rely upon, as a basis for awarding substantial damages. And in my opinion, a great way to get that person to really own up to their lack of knowledge about pain is it's just, are you an expert in the biology of pain? And if you're never going to get a good answer to that question, you never are, because none of these experts who testify in these kind of cases are. And that's because pain is it's the oldest medical condition in the world. It's a very complicated question. And, everyone, and it's true, everyone does experience it differently. So, expose that aspect of the case and then ask them, would a reasonably careful doctor ignore complaints of pain from their patient? Would they just ignore it and dismiss it out of hand because, they may have some sort of suspicion that maybe this isn't, their pain level's really at a 2 when they're telling me it's a 7? Just again, expose what they're doing, call out the game, and you will be rewarded.
Any of us that have read medical records know they break down sort of like this: history, subjective, objective, impression, plan, right? Ask the expert, why do you take a history? Why do you get that? Where do you get it? Do you get it from the patient or from other records? What is this section subjective? What is that for? But you're here telling us that none of that matters, that the history and the subjective that are subjectively from the client, they're the one telling you all of these things. None of that's relevant. Why do you do it? What's the purpose? And just watch them flail like a, fish out of water. They have to now explain why the thing that's in every medical record is irrelevant. Why do it? If it doesn't matter, why document it? If you didn't document it, that would be malpractice. And I'm not going to go that far, right? But it would be. And so they have to try to justify explaining it away. And there's not a good way to do that.
Another thing that you're going to hear often from experts on the defense side is, if your client stopped treating for a while, or there was a gap in treatment for one reason or another, they're going to try to use that as evidence. Oh, your client's the injury resolved. Nothing to see here. Maybe up until the date the gap started, maybe that was related. But if they picked up treatment later on, that torn rotator cuff that they discovered later on an MRI, that has nothing to do with the accident or the fall. Again, and this is something you need to talk about with your client beforehand and have them testify to at their deposition, but have them talk about why did you stop going to treatment? And you'll find out it's because people go to treatment because they want to get better, because they want a cure, they want a fix. And talk about all the things that go into just going to the therapist's office for rehab, 3 times a week. You got to get in your car, you got to drive all the way across town, you got to park, you got to go into the office, you got to sit, you got to wait for your turn, you got to do your exercises, then you got to get back in your car, drive away all the way back across town to your job. And you got to do that again 2 days later. And if you're not getting any improvement from those, what is your incentive to keep going? There's a reason why people stop going to treatment. And a lot of the times it's because they're not getting any better. It's not because the problem's gone away. It's not because, they're cured. It's because, in fact, it's the opposite. It's because they're not cured. It's because they've decided to try to move on with their life. And you can try to expose that through your examination of the defense medical expert. In addition to, obviously, you got to get your client to get on board and testify the same way. But, that's something that you can get into, have them walk through all the things that go into, like I said, just going to one therapy appointment and repeat that, however many times your client had to go, and that takes a toll. That's exhausting. I mean, and especially if you're not getting anything out of it. So make sure you explore that with the expert as well.
And if you think that the gap in treatment argument is going away, well, buckle up, everybody, because we just had a year-long gap in everybody's treatment. No one is regularly and consistently treating the way that they did prior to March of 2020. They just aren't. I have clients who I know need surgery, who need injections, who just aren't getting those things done because they don't want to risk their health, right? Having a surgery makes you at higher risk for the complications associated with the pandemic. And so they don't want to take that risk. And that's understandable. And you might have an out for some juror, you might be able to explain that away to some jurors, but there is a contingent in this country that believes this is all nonsense and that it's not going to be enough for them. So this defense is going to carry some water, and you have to be able to use your client's, subjective and objective testimony to say, why didn't you treat? Well, I wasn't getting any better. And then, this happened. We all got locked in our homes and we, were locked down for whatever. And then I just stopped and I never picked it back up. I didn't think about it. Are you still in pain? Yeah, I'm still in pain. Of course I am. I'm in pain every day and it's horrible. And I wish it would go away. And I never had it before this crash and before, this all happened. And I don't want to be here. I don't want to be in court. I don't want to be in front of a jury. I want to be home and I want to feel better. And if you can get your client to say things like that, which are all true, you're going to be able to explain away these gaps in treatment. But otherwise, they can be pretty deadly. I mean, they're snake bites sometimes.
Yeah, that is really a tough one, and you need to approach that with caution and really make sure that your client is doing it, him or herself a service by explaining why it is that the treatment stopped at a given point. And this last, I'd say, very common opinion that you hear from a lot of these defense experts, last but not least, I would say, is that the injury just resolved. This was a sprain strain. These resolve in weeks to months. And that as of a certain day, we'll call it 3 months out from the accident, just for, to give the client, a little bit of leeway. Any pain and debility after 3 months from the accident is unrelated. That's part of some degenerative process. It's, malingering, whatever it is. It's just, it doesn't really matter what it is because it's not part of the accident. You're going to hear that over and over and over. And again, that's a common sense argument. You don't really need to get into medicine about that. Same pain, same area. If they went to sleep one day with that pain to that area and it was related to the accident, they woke up the next day with that same pain to the same area, but it's unrelated. I mean, point that out over and over and over again. It's not going to stop the defense from putting it out there. They're going to say, the nature of these injuries is a weeks to months resolution, but just point out the absurdity of it all and, just hammer it home that, this is not, that's just not how things work. Make sure that the jury knows that and make that clear.
I see this in every TBI case, every single one of them. Your client didn't have a concussion because she didn't say that she had a concussion in the emergency room. And so there wasn't one. She just had a sprain strain. And then she had some physical therapy and then she got better. She probably didn't even need all the physical therapy that she had. She did 6 weeks of it and she really only needed 2. And she doesn't have any concussion or post-concussive syndrome or mild traumatic brain injury or anything like that. This is where knowing the literature, knowing the medicine, being able to use it is effective, right? So using TBI as an example, 56% of TBI aren't properly diagnosed in an emergency room. So that opinion is garbage and you can immediately destroy it, right? But you have to know the literature and you have to know the medicine if you're going to move beyond the very logical conclusion, which is, like you said, they didn't have this pain before the incident, before the accident, before the trauma. Now they have it. Now it's all the time and every day. It isn't gone. Whether it should or should not have resolved is not an issue, right? This person is not the lab rat of what should or should not have happened. It's an actual human being that is in pain and is suffering. And whether or not it did resolve is the issue. And it has not resolved. And exactly your point. They went to bed with it. They woke up with it. Monday is no different than Sunday. If you say the cutoff is Sunday, but they still have it on Monday, they still have it. And if they tell you objectively, that they still have this today, then they still have it. And then you can sort of argue with the expert and say, well, you believe that this, and this is related to the crash. I mean, you said so in your report, right? But they still have this, and this. They still have chronic headaches. They still have neck pain. They still have a herniated disc at C4-5. They have all those things still, don't they? Yeah. And all those were things you said were related, right? Right. But suddenly, in the middle of May, 6 weeks after the crash, all those things are better. Explain that physiology to me. I mean, it's a little bit of theater. It's a little bit of sort of like the Law and Order moment where you like ask the asshole question and then you withdraw it, which I've been admonished by judges for doing. But it plays really well for the jury, and it exposes the sort of deceptive defense practice that we're talking about.
Yeah. I mean, have them give them an outside date. Have them say, okay, no treatment beyond this date or no symptoms beyond this date certain is related. And then that really, again, pointing out the absurdity of all, highlighting that particular issue and locking them into an opinion, it's really going to benefit you. Again, trial is theater. So you need to have, that moment. You need to have, a nice, clean cutoff date to really highlight the absurdity of that whole line of opinion again. And you see it over and over and over. It's not going away. Anyone who's practicing in this area out there is going to see it. They have seen it. They will see it again. So, learn how to deal with it, try to expose it for what it is, and, just lock them in as best you can.
Yeah. There's a reason why some of the best jury consultants in the world are from a theater background, like David Ball. And there's a reason why places like Trojan Horse Method or Trial Lawyers College use psychodrama and use, portions of acting and those sorts of theater techniques as well, incorporated into how you present a case, because it is theater. And also because America has a love for the courtroom drama on NBC or ABC at 7 Central. They want to see that in an actual courtroom. They want to see a show, right? You have to keep them engaged. The average person has a attention span now of like 8.2 seconds, and then they're on to the next thing. So you have to keep them engaged and entertained. And so a lot of this is theater, but it's important theater because you have a case to prove. And you can use some of these techniques and use some of this sort of theatrical flair to really prove legally what you need to prove in the end, and then show the jury those jury instructions at the end and explain why the defense expert is not a credible witness.
There's some other techniques out there that I've seen from people, obviously smarter and more successful than either of us, that I kind of want to share. There's a concept called negative spacing that I've experienced before I knew exactly what it was. It's the negative spacing term I heard coined by Rex Paris and his firm out in California. And what that really is a technique for deposing the expert. And again, I would defer obviously to him and his firm and their expertise in this area. But the technique basically involves, having your list of all of the documents and all of the people that are involved in your case. And especially if you've got a big injury case, that's going to be a very long list. You're going to have a long list of witnesses. You're going to have a long list of documents, and then just start going through them with the defense expert. Who is, X physical therapist? Who is X attending physician? Who is X psychologist? Who is X psychiatrist? Who is X orthopedic surgeon? And just go through them by name and then see who this person actually can remember and recall without looking at their notes.
That's awesome.
And the reason this is going to be an effective technique for you is because, by the time this expert gets on the stand, the jury's going to have heard all the evidence, basically, because usually the defense expert is going to go on last or close to it. So they're going to have heard from your client. They're going to hear from your client's family, friends, coworkers, treating physicians, your experts, basically everybody involved in the case. And they're going to know who all these people are. And if you're able to show that this defense expert was, skimmed the records in such a way and skimmed the depositions in such a way that he doesn't know who your client's attending physician is by name. He doesn't know your client's orthopedic surgeon is by name. He doesn't know who your client's family is by name, or his brother is the sister, all of that stuff. It's going to show how little they care about this situation. And they were paid thousands and thousands of dollars. And yet they know, the bare minimum as far as facts about the case. And, again, those jurors having been in the courtroom for, 3, 5, 7, 10, 15 days, however long your trial's going, they're going to know all of this information, and they're just going to be absolutely blown away by the fact that this expert who's being paid more than they, 100 times, thousands of times more than they have to be there, they know nothing comparatively. And it really can be a devastating kind of thing. So that's something that has been advocated. I had it done to me once. I haven't done it to anybody. And I can tell you, it was extremely frustrating as a person defending a dep with an expert. And, my expert kept asking to refer to his notes about, who was who. And they kept saying, no, just tell me, you're the expert here. You tell me who these people are. And, I guess unsurprising, the case resolved afterwards. But, I really think it could be an effective tool at trial. And, you can ask the parish firm about how it's worked for them, because the proof's in the pudding with them.
I love it. I absolutely love it, especially because I'm coming to find more and more that a lot of these defense experts rely on a team of, people to summarize the medical records or do abstract the depositions for them. And I know we do a lot of that, right? If we're getting ready for trial, we summarize the records and we abstract the deps and everything else. But if you're the expert and all you read was an abstract of a deposition, you're essentially just reading hearsay. You're reading somebody else's interpretation of it. And so, you can use this sort of technique to really hammer home, you never really even read these records. You don't know who this person is or what they are, because they're not relying on the actual text. And I think this is a better technique than calling them out on, you had somebody summarize this for you. Well, a lot of jurors are going to look at that and say, well, yeah, it's a lot of information. Maybe they did. But the alternative is you never even bothered to read it. You don't know what it is. You have no idea who that person is. Are you kidding me? The incredulity you can express, because it is, it's ridiculous, is awesome. That's an awesome technique. The first time you told me about that, it just blew my mind. I think it's fantastic. I'm excited to use it in the future. I'm sure to many, many objections.
Absolutely. Without question. Another kind of more general technique is keep experts off their report and out of their comfort zone. They obviously know what they have been paid and retained to testify about. They have their version of what happened, however limited that may be. So ask them about things that they don't know, may not know, or wouldn't recall. Ask them about their knowledge of, what the plaintiff was like, what their activities were, about their family, what their wife's name is, what their sister's name is, how many steps are in their house, what kind of car do they drive? All of these different kinds of questions that will expose, again, how unfamiliar they are with this person, their life, and the injuries that they're being paid to testify about. So just, I think that can be a very effective technique as well. It gets them out of their comfort zone. They're going to be, they're going to be shy. They're not going to be within what they feel like they were there to talk about. And I really feel like, again, it can expose these experts for who they are and really do a really nice job for your client and a service to them. And that's going to be it for our episode today. But before we wrap up, we want to give you our 30-second trial tip. One thing we do to make our cases stronger and our trials better. John, what's yours for the week?
As we're talking about experts, I'm stealing mine from a lawyer in California who I know and respect and think is fantastic. His name's Bob Simon, Simon Law Group. He says, while you're sitting on the couch at night watching Netflix, or you're watching a game, or you're doing whatever, pick up your phone and Google the defense expert's name with fraud in quotes, or lied, or lawsuit, or any negative term that you can think of. And just do this for a half an hour to an hour and see what pops up, and save the news articles, save anything that's in the public record to a file that's separate, and have it and go comb through it later. You don't need to sit there and do the research and read. Just find the bits and pieces and collect them all in one place. And then later, as you're preparing for the deposition, you will have all of this information, should it exist, and it'll be very, very beneficial, and it'll create a very effective portion of a cross for you.
That's a great point. Mine for the week is something I was literally talking about earlier today. Don't desensitize the jury to your client's injuries. And you can do that in a number of ways. A lot of times, I do a lot of nursing home cases. You get a picture of a bed sore. You don't want to keep that up the whole time, because after a few days of looking at that, even though it is shocking to see, especially for someone who hasn't seen something like that before, you keep that up for a couple of days and all of a sudden it's part of, the process, the aging process, the dying process. And that's the last thing you want to do for your client. Same if your client has a very visible injury, you may not necessarily want to have them there the whole trial. You maybe want to have them come for opening, closing, have them testify and keep them out of the courtroom the rest of the time, because you want to keep that shock value. You want to make sure that the jury isn't desensitized and has become so used to your client's injuries that by the time they need to make their verdict, everything is kind of, familiar to them. Keep it fresh and make sure that the jury obviously is aware of the full extent of the injuries, but don't overdo it. Don't overplay whatever visual evidence you have of the injuries so much that they become desensitized to it.
Especially if they're those catastrophic injuries like you're talking about, because you don't want them to devalue those in any way, because they are absolutely tragic.
And with that, that's going to be our episode for today. Remember, you can follow us and send us comments, questions, episode ideas, or just troll us on Facebook, Instagram, and Twitter at On Trial Podcast. Please also rate us and leave your feedback on iTunes or wherever you download your podcasts, as it helps us get the word out. Until next time, we'll see you on trial.